Good afternoon, everybody. My name's Edward Denehan, barrister at Ninestone Buildings in Lincoln's Inn. Welcome you to the second of two webinars I've put together to explore some of the main provisions of the Renters Reform Bill 2023. The first webinar took place yesterday at this time, 3 p.m. and dealt with tenancy reform, namely the content of part one of the bill. I left to deal with today one item of tenancy reform, and simply not enough time to deal with it yesterday. And I'll address that final element today before going on to deal with part two of the bill, which is concerned with what are called residential landlords. The form of the segment webinar is that I will simply speak to the papers I provided. I won't cover all the material in the papers, far too much of that, albeit that today's material is rather more modest than that produced for yesterday. But the papers will be circulated to delegates in the next couple of days or so, together with links that will take you to recordings of the webinar. So the webinar, the oral presentation by me, can be looked at again or for the first time for those who can't make it this afternoon. I don't take questions either during or at the end of the webinar. That simply doesn't work in any helpful way. But I'm very happy to deal with any general points or questions or inquiries that delegates have. Simply email me at my Chambers email address on our Chambers website and on the material that you'll receive, and I'll get back to you as soon as I possibly can. I would invite delegates to mute your microphones during the webinar. We have had some interesting unintentional interruptions, so I can invite you to do that. That'd be very helpful. Moving on then to the final part of the tenancy reform in part one of the bill, that concerns unlawful eviction or harassment of occupiers. And it does that by reference to Section 1 of the Protection from Eviction Act 1977. If I can remind delegates of what Section 1 says. Section 1.1 of the 1977 Act is concerned with what is a residential occupier. And a residential occupier in relation to any premises is a person occupying the premises as a residence, whether under a contract or by virtue of any enactment or rule of law giving him the right to remain in occupation, or restricting the right of any other person to recover possession of the premises. So that would self-evidently cover a tenant, an assured tenant, indeed any tenant, but other occupiers too. Section 1.2 contains some teeth. It says that if any person unlawfully deprives the residential occupier of any premises of his occupation or any part thereof, or attempts to do so, he shall be guilty of an offence unless he proves that he believed and had reasonable cause to believe that the residential occupier had ceased to reside in the premises. So that creates a criminal offence. There are subtle additions in the subsequent subparagraphs. So subparagraph 3 of subsection 3 of Section 1 provides that if any person with an intent to cause a residential occupier of premises to give up occupation or part of it, or to refrain from exercising any rights or pursuing any remedy in respect of the premises, does an act likely to interfere with the peace or comfort of the residential occupier or a member of his household, or persistently withdraws or withholds services reasonably required for the occupation of the premises as a residence, he shall be guilty of an offence. Subsection 3 big A of section 1 of the 77 Act provides as follows, that subject to subsection 3 big B, the landlord of a residential occupier or an agent of the landlord shall be guilty of an offence if A, he does acts likely to interfere with the peace or comfort of the residential occupier or members of his household, or B, he persistently withdraws or withholds services reasonably required for the occupation of the premises in question as a residence, and in either case, he knows or has reasonable cause to believe that the conduct is likely to cause the residential occupier to give up occupation of the whole or part of the premises, or to refrain from exercising any right or pursuing any remedy in respect of the whole or part of the premises. Subsection 3B of the 1977 Act provides that a person shall not be guilty of an offence under subsection 3A, that's what I've just referred to, if he proves that he had reasonable grounds for doing the acts or withdrawing or withholding the services in question. And in subsection 3, it's provided that in subsection 3A, landlord in relation to a residential occupier means the person who, but for the residential occupier's right to remain in occupation of the premises, or restrictions on the person's right to recover possession of the premises, would be entitled to occupation of the premises and any superior landlord under whom he derives title. Subsection 4 provides for the punishment for an offence under the earlier subsections. A person guilty of an offence under section 1 is liable on summary conviction to a fine not exceeding the prescribed sum, or to imprisonment for a term not exceeding 6 months, or both. On conviction on indictment, to a fine or imprisonment for a term not exceeding 2 years, or to both. Subsection 5 of section 1 makes it clear that nothing in the section 1 of the 77 Act is taken to prejudice any liability or remedy which a person guilty of an offence under the section may have in civil proceedings. Subsection 6, the final subsection I need to trouble you with, concerns corporate offences, and it's there provided that where an offence under section 1 is committed by a body corporate and it's proved to have been committed with the consent or connivance of, or to be attributable to any neglect on the part of any director, manager, or secretary, or other similar officer of the body corporate, or any person who was purportedly acting in such a capacity, he, as well as the body corporate, shall be guilty of an offence and shall be liable to be proceeded against and punished accordingly. So that's the law as it stands under section 1 of the Protection from Eviction Act 1977, and as I've just explained, it creates criminal offences, punishment by fines and imprisonment, or both. It's clause 22 of the bill that makes amendments to section 1. The substantive amendment is the insertion after section 1 that I've just read of a new section 1 big A, which will introduce financial penalties for offences under section 1. The offences created by section 1 are not being replaced by financial penalties under the new section 1A. A financial penalty may be imposed in lieu of prosecution as provided for in section 1 as it currently stands. Thus, a person may not be convicted of an offence under section 1 in respect of any conduct if a financial penalty has been imposed under the section 1A in respect of that conduct. That's clause 22(2). Under the new section 1 big A, a local housing authority may impose a financial penalty on a person if satisfied beyond a reasonable doubt that the person has committed an offence under section 1 in relation to premises in England. No financial penalty can be imposed in respect of any conduct if the person has been convicted of an offence under section 1 in respect of that conduct. Criminal proceedings for an offence under section 1 in respect of that conduct have been commenced but not concluded, a person has been acquitted of an offence under Section 1 in respect of that conduct. The amount of the financial penalty is determined by the local authority imposing it, but it must not be more than £30,000. The Section 1A5, what will be Section 1A5 of the 1977 Act, provides that the Secretary of State may give guidance to local authority about the exercise of their functions under the new Section 1A, and they must have regard, the local housing authorities must have regard to that guidance. A new Section 1A6 gives effect to a new Schedule 1A to the 77 Act, and that schedule makes provision for the procedure for imposing financial penalties, appeals against financial penalties, enforcement of financial penalties, how local housing authorities are to deal with the proceeds of financial penalties. The procedure described in Schedule 1A is somewhat involved, and alas, like so much in the bill, doesn't lend itself to any palatable oral presentation, but I will distribute with the papers a copy of Schedule 1A, which contains the details in respect of the imposition, recovery and retention, if possible, of financial penalties. So that's all I'm going to say about tenancy reform as reflected in the proposed in the bill. I'm now going to move on and speak to part 2 of the bill, which is concerned with residential landlords. Unlike the bulk, if not all, of what we considered yesterday, part 2 introduces new provisions. Yesterday's webinar was taken up for the most part with amendments to the Housing Act 1988 and additions and insertions and deletions from that act. What we have in part 2 is, if I can put it this way, new stuff. I'm bound to say that it looks particularly burdensome, and if there was ever a reason not to become involved in the as a landlord or become involved in the letting in the private sector, this will add to the burden and therefore make it perhaps a less attractive investment for those who are so invested at the moment. But there it is. The part 2 has 3 chapters. The first is a definition of residential landlord. It also contains other definitions. And then chapter 2 deals with something called landlord redress schemes. And the chapter 3 is concerned with the private renter sector database. We'll look at these in turn, but there are clues in the names as to what these provisions are going to introduce. The Renters Reform Bill 2022-23 research briefing, which was produced for use by the members of Parliament, it provides a following description of part 2 of chapter 2 of part 2 of the Act, that's landlord redress schemes, and it provides as follows. It says this part includes provisions to enable the government to approve or designate one or more redress schemes which all private landlords who rent out property in England will be required to join. So pause there for a second. All residential landlords as defined, and we'll look at the definition in a moment, will be obliged to join the redress scheme. No option there. The government intends to only approve one redress scheme, and for this to be an ombudsman. Requiring landlords to join the scheme will mean tenants and landlords have access to a streamlined service. They go on to say that the ombudsman will investigate tenant complaints and provide fair, impartial and binding resolution to many issues, including those relating to property standards, repairs, maintenance and poor landlord practice and behaviour. The scheme, it said, is expected to be quicker, cheaper and less adversarial than the court system. I pause there to make the point that I don't see how it can be less adversarial, in the sense that if a tenant alleges, for example, that the landlord has been in breach of some repairing obligation, and the landlord denies that, then the issue between the parties in the scheme will be exactly the same as it would be before a district judge or a circuit judge in the county court, or query whether the ombudsman is better placed to resolve such issues than a judge of some kind, probably more cheaply, possibly more rapidly, but the difficulty is that landlords may feel that they won't have a proper say in the debate, and in order to have a proper say, it seems to me that one would have to have very much a procedure very much like a trial, but then that defeats the purpose of the scheme. But perhaps I'm a cynic and somebody who makes their living out of disputes of law, but there it is. The description goes on to provide that landlords who fail to join the scheme can be fined up to £5,000 by the local authority. If the landlord repeatedly breaches the requirements, they may be fined up to £30,000 and face criminal proceedings. They optimistically then go on to describe how the ombudsman will have powers to put things right, including compelling landlords to issue an apology, provide information, take remedial action, and/or pay compensation up to £25,000. It will be mandatory for landlords to comply with any decision of the ombudsman should the complainant accept the final determination. And its final observation is the intention is for the approved redress scheme to be self-funding through membership fees. So it will mean that in order to let residential accommodation in the UK in the private sector, landlords will have to join the scheme and will have to pay for the privilege. I now turn to the detail, and I start, sorry for jumping back, but this is how it's arranged in the bill, to the meaning of residential landlord, and that's the starting point. In part 2 of the bill, a residential landlord means the landlord under a relevant tenancy of a dwelling in England that is not social housing. A dwelling means a building or part of a building which is occupied or intended to be occupied as a separate dwelling. That's a very familiar definition. Social housing has the same meaning as in part 2 of the Housing and Regeneration Act 2008. Section 68(1) of that act provides that social housing means low-cost rental accommodation and low-cost ownership accommodation. Accommodation is low-cost rental accommodation if it is made available for rent, the rent is below the market rate, the accommodation is made available in accordance with rules designed to ensure that it's made available to people whose needs are not adequately served by the commercial housing market. Accommodation is low-cost home ownership accommodation if the following conditions are satisfied. Condition 1, that the accommodation is occupied or made available for occupation in accordance with 1, shared ownership arrangements, 2, equity percentage arrangements, or 3, shared ownership trusts. Condition 2, that the accommodation is made available in accordance with rules designed to ensure that it is made available to persons that should be whose needs are not adequately served by the commercial housing market. In clause 23 of the Act, of the bill, forgive me, a relevant tenancy means an assured tenancy within the meaning of the Housing Act 1988, or a regulated tenancy within the meaning of the Rent Act 1977. A regulated tenancy under the 1977 Rent Act is a protected tenancy or a statutory tenancy, and there are still such tenancies in existence, but they are becoming fewer and fewer in number for reasons that are obvious. Under clause 23, the Secretary of State is given power to amend Chapter 1 of Part 2 by regulations. As I mentioned yesterday, and I mentioned it again, that the bill contains numerous provisions which enable the Secretary of State to make regulations altering the impact and the scope of the provisions when they are enacted. Under clause 23, the specific power, the Secretary of State may change the meaning of residential landlord in relation to an assured tenancy that is a subtenant. See? Change the meaning of relevant tenancy to add or remove a particular kind of tenancy of a dwelling that is a periodic or granted for a term of less than 21 years, or to a license to occupy a dwelling. Change the meaning of dwelling so that it includes any other structure, vehicle, or vessel occupied as a separate dwelling or intended to be so occupied. So there we have a very good example, I suggest, of the power of the Secretary of State to vastly expand the scope of the operation of Part 2 of the Act. So let's get into the nitty-gritty of the landlord redress scheme. And the definition that I have on the screen now comes from clause 24.2. And a landlord's redress scheme is a scheme which provides for a complaint made by or on behalf of a prospective, current, or former residential tenant against a member of the scheme to be independently investigated and determined by an independent individual, and B, which is approved by the Secretary of State for the purposes of regulations under what will be section 24.1, or administered by or on behalf of the Secretary of State and designated by the Secretary of State for those purposes. So what jumps out at the page in those circumstances, or sorry, by reference to the definition of a scheme, is that it's not limited to issues arising between the landlord and the tenant, but issues arising between a former landlord and tenant, and indeed between a prospective landlord and tenant. So one can imagine a dispute arising as between a prospective landlord and a prospective tenant, for example, about the landlord not providing information or misleading information, and so on and so forth. And former residential tenant, one can see, are often disputes when tenancy comes to an end about damage caused by the tenant or not, or deposits and so on and so forth. But the deposit scheme will remain in place. Nothing proposed in the bill impacts on that. Clause 24.1 empowers the Secretary of State again to make regulations requiring a residential landlord to be a member of the scheme. There's a definition of what is a prospective residential tenant, and that is a person who offers to become a residential tenant of a dwelling that is marketed for the purposes of creating a residential tenancy, or with a view to deciding whether to become a residential tenant of a dwelling that is marketed for that purposes, requests information about the dwelling from a person marketing it, or visits or requests to visit such a dwelling by arranging with such a person marketing it. I can imagine that my experience with properties over the years on a personal level is that arranging visit often leads to frustration when the agent doesn't arrive. I suppose that could be the subject of a complaint and marked on the prospective landlord's record, and as we shall see. The regulations made by the Secretary of State under clause 24.1 may require a person to be a member of a landlord redress scheme before a dwelling is marketed for the purpose of creating a residential tenancy under which that person will be a residential landlord. So the Secretary of State can make regulations that you've got to join the scheme before you can even market property. Prohibit a person from marketing a dwelling for the purpose of creating a residential tenancy unless the person who will be the residential landlord, if the tenancy is granted, is a member of the landlord redress scheme. Require a person to remain a member of the scheme after ceasing to be a residential landlord for a period specified in the regulations. So the landlord can't avoid the jurisdiction of the ombudsman, or yes, it's an ombudsman under the scheme, simply by ceasing to be a member of the scheme when he or she ceases to be a residential landlord by taking, I'm paraphrasing, taking the dwelling off the market. That makes perfect sense, because as we mentioned a few moments ago, often disputes arises between landlords and tenants when the tenancy has come to an end, and the landlord can't escape potential consequences of his or her conduct by simply dropping out of the scheme. A landlord redress scheme can provide for membership to be open to persons who wish to voluntarily join. That's clause 24(6)(a), and for the investigation or determination of any complaints under a voluntary jurisdiction and for voluntary mediation. Complaints under a voluntary jurisdiction means complaints in relation to which there is no duty on the member of to be a member of a landlord redress scheme, where the member against whom the complaints have made have voluntarily accepted the jurisdiction of the scheme over the complaints. Voluntary mediation services means mediation, conciliation, or similar processes provided at the request of a member in relation to complaints made against the member or by the member against the person. That's clause 24(7)(b). So as I understand that, how it would work, that if what we'll call the landlord was not a residential landlord within the definition in clause 24 of the bill, he or she could still volunteer to be a member of the scheme and then have the benefit of and the burden of the procedure in the scheme for addressing complaints made. Before a landlord redress scheme is approved or designated under clause 24, it must satisfy certain conditions set out in regulations made under clause 24(1). The conditions must require the scheme to include the following provisions. First, for the administrator to appoint an individual, having obtained the approval of the Secretary of State, who is to be responsible for overseeing and monitoring the investigation and determination of complaints made under the scheme. And as explained in the briefing notes prepared for the Commons, and which I've mentioned earlier, that person will be an ombudsman. The scheme must also contain provisions about complaints that may be made under the scheme, which must include provisions enabling the making of complaints about non-compliance with any codes of practice for residential landlords that are issued or approved by the Secretary of State. The scheme must also contain provisions about the time allowed for the scheme members to resolve matters before a complaint is accepted under the scheme in relation to the matters. Provisions about the circumstances in which a complaint may be rejected. Provisions about cooperation of an individual who is investigating or determining a complaint with persons who have functions under other redress schemes and with local housing authorities. There aren't going to be any other redress schemes at the moment, so it's a reference to local housing authorities only that is relevant. The scheme must contain provisions about the provision of information to the person mentioned in clause 25(2)(e), that's the Ombudsman and the Secretary of State. If members are required to pay fees in respect of compulsory aspects of the scheme, about the level of those fees, well, we know that they will be members will have to pay a fee, and that fee will finance the entire scheme. I simply have no idea what the level of charge will be, and I've been unable to obtain information as to any suggestion as to what that fee, what the fees might be. If there are voluntary aspects of the scheme must make provision for the fee to be payable in respect of those voluntary aspects of the scheme, and for the fees to be set at a level that's sufficient to meet the cost incurred in the administration of those aspects of the scheme. Voluntary aspects mean aspects of the scheme relating to complaints under a voluntary jurisdiction, voluntary mediation, or voluntary members, which we mentioned a moment ago. The scheme must also, will, contain provision for the individual determining a complaint to be able to require members to provide redress to the complainant, including providing an apology or explanation, paying compensation, taking such other actions in the interest of the complainant as the individual determining the complaint may specify. It may well just be me, but I must confess, I'm not sure that many people will seek to engage with the scheme simply for an apology, but again, that may be me. And the scheme must contain provisions about the enforcement of its scheme and decisions made. It must contain provisions for a person to be expelled from the scheme only in circumstances specified in regulations, once steps have been taken to secure compliance, and once the decision to expel has been reviewed by an independent person. That's quite an important provision because, as we've noted, that in order for a residential landlord to let dwellings on assured tenancies, he or she must be a member of the scheme. So if he's thrown out of the scheme or expelled from the scheme, that means that this individual is, if you will, out of the private sector game until such time he's able to rejoin. The scheme must also contain provisions for expulsions to be revoked in specified circumstances. Again, the circumstances for expulsion and for expulsions to be revoked are being prescribed by regulations, and I haven't been able to see what those regulations might look like, but one can see, certainly in respect of being expelled, that if one has an habitual offender, if you will, a bad landlord, then he or she may well be expelled from the scheme. And as we've just said, if that happens, then they're not in the market. The scheme must also contain regulations prohibiting a person from joining the scheme when that person has been expelled from another landlord redress scheme and the expulsion has not been revoked. I repeat the third time now that it seems, certainly in the short term, there's not going to be another scheme, and one can see the good sense of that. If there were competing schemes, if you will, then a rogue landlord could bounce around from scheme to scheme and thus remain in the housing market, as it were, notwithstanding their delinquent behaviour. The scheme must also contain provisions for the circumstances in which the administration of the scheme is to be transferred to a different administrator, and it also must contain provisions about the closure of the scheme by the administrator. An important provision concerns, again, financial penalties, and this is to be found in clause 26 of the bill. It's there provided that a local housing authority may impose a financial penalty if satisfied beyond a reasonable doubt that a person has breached the regulations or committed an offence under clause 27, and I'll mention those in a minute. The amount of the financial penalty must not be more than £5,000 if imposed under clause 26(1)(a), or £30,000 if imposed under clause 26(1)(b). Clause 27 of the bill will create 3 offences. If a relevant penalty is imposed and not withdrawn, and the conduct in respect of which the penalty was imposed continues after the end of the period of 28 days, beginning on the day when the penalty was imposed, or the day after an appeal is finally determined, withdrawn, or abandoned. So if there's a penalty imposed and the landlord continues with the untoward behaviour for a period of 28 days from the date the penalty is imposed, then they will commit an offence under clause 27. The second offence is if the relevant penalty has been imposed in breach of regulations and not withdrawn, and the person engages in conduct which constitutes a different breach of the regulations within the period of 5 years, beginning with the day on which the penalty was imposed, that also constitutes an offence. So if you've got a bad record, if you will, then you will be guilty of a criminal offence. The third criminal offence is this: either one, a relevant penalty has been imposed on the person in respect of an offence under clause 27, and two, the final notice imposing the penalty has not been withdrawn, or three, the person has been convicted of such an offence, and four, the person breaching regulation within the period of 5 years beginning on which the relevant penalty was imposed or the person was convicted. A relevant penalty for these purposes means a financial penalty which is imposed under clause 26. An offence under one of the three offences under clause 27 may be committed by a body corporate. In such a case, if it's been committed with the consent of or connivance of, or to be attributable to any neglect on the part of an officer of the body corporate, the officer as well as the body corporate commits the offence and is liable to be proceeded against. So the Acme Letting Limited could be guilty of an offence, and also Mr. Smith, the leading light director of that company, could both be guilty of offences under clause 27 and punished accordingly. Clause 27A provides that where the affairs of a body corporate are managed by its members, clause 26.7 applies in relation to the acts and defaults of a member in connection with the member's functions of management, as if the member were an officer of the body corporate. 26.7 was the provision I referred to just a moment ago about officers being consenting or conniving with the committing of offence. Clause 28.1 provides that the Secretary of State, surprise, surprise, may make regulations for provision for the administrator of a landlord redress scheme to apply to a court or tribunal for an order that a determination under the scheme and accepted by the complainant be enforced as if it were an order of the court. I assume on those broad words that there is potentially no limit to the order of the ombudsman being imposed on a delinquent landlord and taking effect as if it were an order of the court. Self-evidently, that would be an order for the payment of money, compensation, if you will. That would be a money judgment and could be enforced against the landlord in the way that money judgments are. Ultimately could lead to his or her bankruptcy. Could be an order for specific performance if there is a requirement for the landlord to do something like repair, connect services, or whatever there might be. It'd be an interesting order of the court to require a landlord to apologise, but we'll wait to see how many times the ombudsman will make a discreet order for a landlord to simply apologise for some misbehaviour on his or her part. Clause 29 of the bill provides that the Secretary of State may from time to time issue guidance for local housing authorities in England and the administrators of the landlord redress schemes about cooperation between such local housing authorities and persons exercising functions under the scheme. Again, as far as I'm aware, regulations have not been made, and I'm not aware of any guidance that has thus far been issued by the Secretary of State. Again, I'll say that there are endless provisions in the bill which provide for the Secretary of State to make regulations. As I mentioned yesterday, the sponsoring department, the head of the sponsoring department, Secretary of State, Michael Gove, recently said that as little or nothing in the bill is controversial, it will become law before the end of 2023. I assume there's some civil servants working very hard at the moment to knock these regulations into shape. One knows from experience that regulations that are involved and copious and produced in a hurry hardly ever contain any errors or omissions, but we'll see. The final element of the residential landlord, part 2 of the bill that I want to address, is something rather sinisterly called the private renter sector database. The overview provided by the research briefing I've referred to several times now provides this overview of the private sector rented sector database. It says Chapter 3 of Part 2 of the bill includes provisions to establish a private rented sector database, which will support a new digital property portal service. This database is intended to, 1, help landlords understand their legal obligations and demonstrate compliance, provide information to tenants, enabling them to make informed decisions when entering into a tenancy agreement and hold their landlords to account, and 3, assist local authorities to target enforcement activity where it is most needed. All private landlords will be required to register themselves and their properties on the property portal. Landlords who fail to register themselves on the or their properties may be fined up to £5,000 by the local authority. If a landlord repeatedly breaches the requirement, or if they provide false or misleading information to the property portal, they may be fined up to £30,000 and or could face criminal prosecution. The bill provides for regulations which will set out the details, including how the database will be operated and overseen, what information will be entered on the database and made public, how entries may be verified, corrected and removed, registration fees, and how information on the database can be shared with third parties. The Department for Levelling Up, etc., has published guidance on the private rented property portal. That was in May of this year. This confirms the government will introduce the property portal as soon as possible after the Renters Reform Bill has received royal assent. There are extensive provisions dealing with this wretched database set out in the bill. As one might anticipate, a database with information about individuals, companies, and properties is a sensitive exercise. And if this property portal is going to be open to inspection by potential tenants and third parties and so on and so forth, then one can see that one needs some care as to what information is required and how that information might be used. So I won't speak to all of that, it's just too extensive, but I'll provide the following snapshot. The database must, according to the bill, this is clause 32, must contain the following: entries in respect of persons who are or intend to become residential landlords. We go back to the definition of residential landlords that I started my consideration of this part of the bill. Entries in respect of dwellings which are or are to be let under residential tenancies. Entries in respect of persons whom relevant banning orders have been made, who have been convicted of or whom financial penalties have been imposed in relation to relevant banning order offences, and 3, who have been convicted of offences on whom financial penalties have been imposed or have been subject to regulatory action. A banning order is an order that prevents an individual from being a residential landlord. That's what that is. So one can see that one's criminal record will be on the, if one has one, in the context of housing, will be on the the database for all and sundry to look at and act accordingly. Again, regulations will require a fee to be paid in respect of entries on the database, but the level of fees has not yet been fixed. A person cannot market a dwelling for the purposes of creating a residential tenancy unless there is an active landlord entry in the relevant database and there is an active dwelling entry in the database. The database operator must give access to the information to the database to the following organizations: lead enforcement authorities, local housing authorities, local weights and measures authorities in England, mayoral combined authorities as defined by section 107 big A8 of the Local Democracy, Economic Development and Construction Act 2009, and the Greater London Authority. That's all clause 46 of the bill. Clause 45 of the bill makes provision for the use of information from the database. The bodies that I've just read out may only use the information for their functions relating to housing, residential landlords, or residential tenancies. The final point I wish to make in respect of the database is this: a landlord or a dwelling entry will be removed from the database if it has been inactive throughout a continuous period of 5 years. If an entry is made in respect of a banning order under clause 40, the entry will be removed at the end of a period of 10 years, beginning with the day on which the entry was made. Unless the period of the banning order continues after the period of 10 years, in which case the entry will be removed at the end of the banning order. I repeat, that's all I need or want to say about the database, and indeed all I'm going to say about the provisions of the bill. The notes are more extensive than the oral presentations of today and tomorrow. I apologize for the webinars being slightly unbalanced in that regard. And I repeat, they will be distributed with the links to the recordings and the PowerPoint slides, typos and all, within the next couple of days. I thank you for subscribing to these webinars, and for those who make the effort to actually attend, very much appreciated. And watch this space for the next series that we'll be putting out probably in the autumn, early autumn. So again, I thank you for coming along, and I wish you all a good afternoon.